This mini lecture is on intellectual property, sometimes called IP, strategy. It's part of the course on technology strategy given by the Department of Engineering Science at the University of Oxford. The key purpose of any IP strategy is to protect the distinctive competencies that you and your company have put together. A very good website to have a look at is www.ipo.gov.uk, and that links you to this longer website. It's well worth having a look there to see some interesting aspects of IP. In general, there are 6 aspects of how to protect your IP. Firstly, patents, designs, trademarks, copyrights, using open source, and protecting your know-how. Let's have a look in detail how these actually play out. The first of these is patents. This is normally what most people think about as IP strategy. However, it is only one part of 6 potential strategies. The key thing about a patent is it protects how the device works. It doesn't protect what it looks like or a particular instantiation, but rather exactly what goes into it to make that particular device work. In order to file a patent and to get it granted, the patent needs to meet 3 essential criteria. The first of us is that it needs to be novel. In other words, nobody else in the whole wide world needs to have come up with this particular idea. There have been instances where a person has filed for a patent, for instance, for a bell that a dog can use to let his person know that it wants to come into the home. However, the patent officer happened to find a Beano copy which had a particular variation of this theme, and therefore the patent wasn't validated. The second thing is that the patent needs to have an inventive step. In other words, it must be something that nobody competent in the art of that particular area may be able to routinely come up with. And the third aspect is that it must be able to be made. You'll see that if we look at examining patents, that there's a big section on how to make that particular device or a range of devices using the ideas put forward in the patent. This ensures that perpetual motion machines and the like cannot be patented. A patent only lasts for a certain time scale, and typically in most jurisdictions you are given 20 years of protection. There are some catches to a patent. The first of all is that the patent is published and therefore is disclosed to the whole world. Everybody can go and look up your particular patent and understand how your particular device works, but you only get protection in the jurisdiction that you file a patent. This means if you want to be protected in a number of countries, you need to file a separate patent in each one of those particular countries. In each country, the patent is completely reassessed again against the prior art, and sometimes different patent examiners may find a different material in which to try and refute your particular claims. Lastly, you've got to remember that your patent is not fully protected until and only until it is tested in a court of law. This means that in order to be able to justify that your patent is worthwhile standing up in court, you need to have a substantial budget in order to pay the lawyers to fight the case on your behalf. So, a patent protects how the device works. It needs to meet these 3 criteria, protects you over a scale of 20 years, disclosed to the whole world but only enforced in a particular jurisdiction, and all it does is it gives you the right to go and get it tested in a court of law. Even if you're not intending to file a patent, you still need to be aware about them, because in developing your new innovative product, you may well be violating somebody else's patent. If this is not the case, then you have what's called freedom to operate. In order to check whether you do have freedom to operate, one undertakes a patent search to see what else has been done in this space and to see whether you are indeed violating somebody else's patent. If you do find them, there are a number of options. The first, but not the most useful, is to ignore this patent. And this has been done in cases such as Apple and Nokia, where they have continued to produce a product even though they have willingly and knowingly violated the other's patent. The second thing to do is to check whether the patent has been lapsed or expired. A lapsed patent is when the fees to maintain the patent have not been paid, and therefore the patent lapses. An expired patent is when it has gone beyond the 20 years. In that case, the information is deemed to be in the public domain, and you can use it to your heart's content. The third option is if it's neither lapsed nor expired, and you don't want to ignore it, is to license it. An example of being able to license a patent is that for an MP3 player. Every time you make a MP3 player, you need to license around about 20 to 30 patents. Fortunately, you only need to deal with one body in order to license all of them together. The next option is to challenge the patent, and this has, for instance, been done between Samsung and Apple. And that is where they say there has actually been prior art, and therefore the patent is no longer valid because it's not novel. The last option, and the most common option, is to try and find a workaround. You now understand what they've done. Now, is there a clever way in order to be able to do the same objective, but in a method that won't be covered by the patent? A registered design protects what the device actually looks like. It doesn't protect what it does, but what it looks like. In order to be able to file a registered design, you need to be able to meet the three following criteria. First of all, it has to be something that is new, and it cannot register an existing design that has not been registered in the past. Secondly, it has to have a striking and individual character. Thirdly, you cannot protect for a matching. In other words, producing a registered design for a particular way a connector connects together. This provision was originally brought in for the automotive industry, where people were using registered designs to, for instance, stop people producing fan belts or connectors or hoses because they had a registered design of the way the parts connected together. And this protection was added into the registered design to allow for competition. A registered design, again, has a limited timescale, and this time it's typically of 25 years. Once again, you need to file it and protect it in each jurisdiction that you want to sell it in. And again, it's only protection in a court of law which guarantees that you are truly protected. An example of this is where people have considered IP violations between Apple and Samsung was not to do the way a particular product worked, but rather the way particular icons looked. And have a look at that website there to see the interesting outcomes. Thirdly, we have trademarks. Trademarks protect the logo or the mark, which establishes a brand identity within the market. There are many exclusions. For instance, in the last few decades in the UK, you may not use English words. Secondly, a particular trademark is only associated with a particular market. So, for instance, we had the interesting case where Apple was registered both as a music company, that did the Beatles, and secondly, a computer company. And the interesting challenge was when the computing company started to stray into the music sphere, and therefore there was litigation around the use of the trademark Apple. Trademarks offer an indefinite time protection, and therefore once you have a trademark, you have it for the rest of eternity. There are two ways of filing a trademark. There's a registered trademark, with use the symbol R for registered trademark, and there's an unregistered trademark, TM. An unregistered trademark, you may simply just add the words TM to your brand, and therefore that starts to give you protection from that moment forward. Once again, trademarks only can be enforced through the courts. Therefore, ensure that you have a sufficient budget to pay your lawyers. The fourth aspect of being able to protect your IP is that of copyright. Copyright protects the expression of a particular idea. So, for instance, a computer source code or website can be protected under copyright. However, one has to be a little bit careful because it's that expression which is protected. So a variation on the source code is not protected, or a variation on the website is not protected. Secondly, the timescales that you have protection under copyright are various depending on the particular material you have. So, for instance, if you're trying to copyright a book, then it's something like 50 to 70 years after the death of the author. Filing is much simpler. It's simply automatic, and any material that is published is deemed to be copyright. You may add the words with a symbol with a C around it, with the author and the date, and that makes known to the world that you wish to have that material copyrighted. You may also, to have added protection, lodge that particular copyright with a solicitor. So that ensures that you have a particular date at which the particular material is deemed to be copyrighted from. The fifth way seems like a strange way of protecting your IP, and that's open source. However, what it does do is it ensures that you have freedom to operate. That means that nobody else can come along and patent your idea or the way that you do things because you've released it as open source. It promotes a set of alternative values, that of collaboration, giving back to the community, and it uses the creative use of free time. Open source have a number of different licenses, and the way you license is basically just make clear in the particular product what the particular licenses are. There are a couple of variations. So, for instance, GPL1, which is a GNU public license, ensures that any changes that are made have to be open sourced as well. And there's some licenses which restrict you from not using that particular software within a commercial product. There are much more freer commercial friendly licenses such as BSD, which ensures that commercial entities may be able to use that particular license. So for instance, Mac OS X is based on BSD, which is the operating system which was competitive to Linux. Although this is mainly used within the software industry, there are a number of people starting to try and use that in the commercial applications. Go and have a look at the website 40fires to give you an example of what happens in the automotive industry. The most powerful way of protecting your IP is to protect what's called know-how. And know-how is basically that which can't be patented, but is essential to ensure that you produce the right product. And it can be embedded within the people and the personnel that you actually have. You can protect it by ensuring that you have non-disclosure agreements with your particular supply chain, such that they may not have any rights to taking that know-how further on. The key way of protecting know-how is by protecting the people who develop that know-how, and by having good information systems such that when people leave, due to various reasons, whether it's retirement or they're just simply moving on, that the company has captured those essential tasks which enable you to produce that key core product. So an example of using IP. It's a particular case where I was involved in setting up Yasa Motors. We discovered that there was indeed some prior art in the area. However, it had expired and therefore there was freedom to operate in the key core technology. In order to protect oneself, 4 patents were produced which ring-fenced that prior art. In other words, it made it difficult for people to use that prior art in a way which was effective. The design of key components were registered so that nobody could repeat them straight away, and those components also had specific engineered applications within them. The trademark, that of Yasa Motor, was also registered to ensure that there is a robust presence within the market. The embedded controller software was copyrighted, and strong NDAs or non-disclosure agreements were in place with the supply chain. To ensure that we can maintain staff retention in order to maintain the know-how, there were substantial staff reward schemes such as share options to ensure that the people that had the know-how remained within the company. That concludes this mini lecture on IP protection and the strategies to ensure that you maintain the distinctive competencies that you developed within your particular company.